Hi, everyone. Thank you for joining. We'll get started in a couple minutes. Wait for a few other folks to log on. Welcome, everyone, to our November webinar for the Legal Network for Gender Equity. Today, I'm thrilled that we'll be introducing to you all a recently released resource that we're excited to share with advocates and attorneys who assist survivors, namely Survivors Speaking Out, a toolkit about defamation lawsuits and other retaliation. If we haven't had a chance to meet, I'm Lizzie Vogel, Senior Counsel at the Times of Legal Defense Fund and Legal Network for Gender Equity team at the National Women's Law Center. Before I dig in, I want to extend my sincere thanks to those of you who helped make today possible. First, to our attorneys in the Legal Network, thank you for being here today and for all the work you do on behalf of survivors. Thank you to my colleagues at the Law Center, Danny Stewart and Jennifer Mondino, for your help with today's webinar. And thank you to our fabulous presenters, Emma and Elizabeth, who I'll have the pleasure of introducing you all to further shortly. A few quick housekeeping notes. This webinar is being recorded. We'll share the recording and the slides from today on our website within the next few weeks. As always, you can find these webinars and other resources for the Legal Network on our website at the link that Danny just magically added to the chat. And then Danny, if you can take us to our next slide. Just to give you all a quick rundown of what we'll be talking about today. So first, like I said, I'll start with introductions of our speakers. Then Emma and Elizabeth will provide you all with an overview of the toolkit and share some additional resources for survivors. And then finally, we'll conclude with some time for questions and answers and some brief announcements. So we are really fortunate today to be delving into this topic, guided by two people who are both tremendous advocates for survivors and true experts in today's topics, as they were truly instrumental in creating this toolkit. And though there are many impressive and interesting things to say about Emma and Elizabeth, I'll keep these intros brief. You can see a longer bio for each speaker on the screen, and we send these out by email as well. And then also they will be included on the slides that you can access online. So first, I'd like to introduce Emma Grasso-Levine. Emma is the Senior Manager of Title IX Policy and Programs at Advocates for Youth. In this role, they manage Know Your Nine, a survivor and youth-led project for Advocates for Youth that empowers students to end sexual and gender-based violence in schools. Next, I'd like to introduce Elizabeth Tang. Elizabeth is Senior Counsel here with me at the National Women's Law Center, where she focuses on ending sex-based harassment in school through Know Your Rights education, policy advocacy, and litigation. So now, Elizabeth and Emma, I'll turn it over to you to get us started.
Awesome. Thank you so much, Lizzie, and really, really grateful and delighted to be here with you all today. And thank you for those introductions as well. I want to start off by just giving you a little bit of an overview of our resource that is pretty newly released, and we're really excited to have out in the world, our Survivors Speaking Out Toolkit. And to provide a little bit of background on the impetus for this resource and who authored it. It was really created and written by and for survivors who have faced defamation lawsuits and other retaliation as a result of speaking out about experiences with harassment or abuse that they've experienced. And we really, the idea behind this toolkit came from students and workers coming to us who are also survivors and letting us know that they didn't really see a resource out there to sort of help them navigate what can be a really complicated decision-making process, either when they're considering speaking out or if they have already spoken out and then are experiencing defamation and retaliation as a result. So the audience is really meant to be for students and workers, as well as other survivors who want to speak out about harassment, or already have. And the goal is really to help survivors of all ages understand their rights and risks as well, and options, so that they can make an informed decision about whether to speak out, and if so, how, and if they would like to speak out, how to do so in a safe way. And I really want to underscore here that for us, we really support survivors' autonomy and want to make sure that they feel empowered to make the decision that is right for them, and recognize that for some folks, speaking out might be the right choice, and for others, it may not be. And so our hope is really that this toolkit can be a resource for either category of those folks in terms of making a decision that is right for them about whether or not they choose to speak out. To provide a little bit of a note about contents of the toolkit, we start with a Dear Reader letter that is written from by the authors of the toolkit, myself and Elizabeth included, to sort of do some ground setting around some of the things that I just talked about with you all. The rest of the toolkit, or the majority of the rest of the toolkit, is structured as frequently asked questions. And the rationale for that was we had a lot of folks, students and workers come to us who are survivors saying, with suggestions about questions that they either had when they were considering speaking out or wish they'd known and had the answers to. And so felt like a Q&A format was really accessible to folks. We have a final thoughts letter at the end to close out the toolkit. And then we also have a glossary, as well as an appendix about state anti-SLAPP laws, which Elizabeth is going to go into detail about a little bit later. You can go to the next slide, please. So I'm going to talk a little bit first about parts A and B of the toolkit, which cover both the ways survivors can speak out, as well as things to keep in mind while speaking out. So one of the first Q&As in the toolkit is, what are my options for sharing my story, right? And so we sort of break this down into ways that everyone can speak out, as well as what students and then workers specifically can do to share their story if they choose to. So some of the ways to do that include, in person with folks in your community, online through news outlets. Know Your 9 often supports survivors who want to write op-eds to share their stories or issue public statements, as well as anonymous statements or through police reports. For students specifically, they also can file complaints with the school and with state and federal agencies or through a lawsuit. And then for workers, they can also file complaints with HR or with a union, as well as like students with a state and federal agency or through a lawsuit. Another question that we frequently got was that whether or not it's possible to remain anonymous. And I think, for us, the goal of this toolkit was to make sure that folks feel empowered to speak out if they choose to do so, but also to have an awareness of what the level of risk might be for them. So something that we flag is that there's always a chance that you will be recognized based on the details that you share if you do speak out. And also to flag that some people that you may disclose your story to have an obligation to share your story with other people. So for example, mandatory reporters may need to share it, must share it with police, or some school employees must share a disclosure from a student with a Title IX office, or for employers, they must share with relevant witnesses. So wanting to make sure that folks have that awareness as they're coming to their own decision. And then another thing that we flag also is that even when you do remain anonymous, there's also still the chance that you can be sued. One example of that is that we gave in the toolkit is about a spreadsheet that was created by someone detailing a list of names of different men who had jobs in the media, who had engaged in sex-based harm and inflicting that upon folks. And some of the men who were named in the spreadsheet sued the creator of the spreadsheet for defamation, even though she remained anonymous. So that's just something to keep in mind, as well as the fact that, of course, you can be anonymous in a lawsuit if folks choose to go that direction. And then the last thing that I'll say about different ways to speak out is on the question of what if the person who's speaking out doesn't name their abuser. I think we've really seen this, especially as many of you may have seen in the case of Amber Heard and Johnny Depp, how this played out, but just to flag that someone's abuser may sue them even if they did not explicitly name them in whatever method they chose to speak out in. And then the other thing to flag is that a school or workplace also may punish a student or a worker, even if they don't name their abuser. One example of this that we heard about and referenced in the toolkit is a student in Maine who posted a sticky note in her school saying there's a rapist in our school, and then was retaliated against by the school and punished for putting up that sticky note. So we share that example not to deter folks from speaking out in their schools, but just to make sure that folks understand what the potential reaction may be and take that into account when they're making the decision for themselves. We can go to the next slide, please. Thank you. So to the next section about things to keep in mind while speaking out that we detail in the toolkit. Something that we really underscore is the importance of making a safety plan for anybody who is thinking about speaking out or has spoken out. And we include some links in the toolkit to some really fantastic safety planning guides from Love is Respect and also the National Domestic Violence Hotline. Another question that we got frequently was whether folks should talk to a lawyer about speaking out. And we really encourage folks that if they're thinking about speaking out or have already, it could be a good idea. And if they are facing a lawsuit, then it's definitely a good idea to talk to a lawyer. And then another question under the heading of whether or not to speak with a lawyer and engage there. We often get asked from survivors. I know we get this question frequently with Know Your Nine about where folks can find lawyers, and also just getting a sense before they jump into things, how much a lawsuit could cost. So we provide in the toolkit a breakdown of what hourly rates look like for folks who may not be familiar, and also flagging about other court costs that they might incur, things like filing, printing, postage, etc. And then also the toolkit has some really great info and links to pro bono or low cost legal resources that are available, including the Law Center's Legal Network for Gender Equity and the Time's Up Legal Defense Fund, as well as making sure folks know that they can get help through law clinics, law school clinics, insurance policies, and as well as anti-SLAPP laws. And I think this section of the toolkit is really crucial, speaking from the perspective of someone who speaks with survivors most days in schools who are students and may not have an understanding of, how a lawsuit goes, and also maybe, in school and not have the financial means to afford getting a lawyer. We really think these are crucial resources for folks to know about, because of the financial burden of hiring a lawyer can be a huge barrier for some survivors who are considering speaking out. And then the last 2 points that I'll cover for this section are the question about whether the police can investigate violence, even if a survivor may not want them to, and wanting to make sure that folks know that yes, that can occur. And also in some domestic violence cases, folks could be fined or arrested or even jailed if a judge orders them to testify and they refuse. And then also noting specifically for students that many school and medical staff are mandatory reporters, and making sure that folks understand that telling a school staff member or medical staff member could trigger a police report. And then the last piece is we had a question from folks about, can speaking out publicly affect a civil protection order hearing or a police investigation? And answering that by wanting folks to know that it shouldn't affect whether a court grants a protection order or whether the police investigate, but also wanting folks to know who are considering speaking out that the police may ask them to not share some of that info publicly, so that may impact their decision. And with that, I will pass it over to Elizabeth.
Thanks, Emma. So then we have 2 sections in the toolkit that specifically address things that people should keep in mind if they are speaking out as a student or as a worker. There are actually different sections in the toolkit, but we've sort of combined it here. A lot of the answers are quite similar. And of course, people that you might be working with, survivors, may happen to be both students and workers, and so they might find different nuances in the answers for each section. So a common question is, can speaking out affect my education or my job? And of course, yes, unfortunately, survivors who have spoken out have been punished at work or at school. But one thing that we highlight in the toolkit is that retaliation is illegal. We explain what retaliation is legally, and also just highlighting for survivors so that they know that they have a right against retaliation. Specifically for students, we also talk about how they can ask their Title IX office for supportive measures. So as you can see, there's a link right there to a supportive measures FAQ that the National Women's Law Center also collaborated with Know Your Nine, including student survivors on. And that supportive measures FAQ explains how if the harassment itself, or if the speaking out against the harassment has affected a student's access to education, they can go to their Title IX office to ask for supports like tutoring or an extension on deadlines, or access to counseling, an opportunity to resubmit an assignment or retake an exam, a safety plan. There's so many different types of supportive measures. I'm not going to go into all of them, but we highly recommend that folks check out that resource to understand what their options are in terms of staying safe and making sure that as much as possible, access to education is not affected. And then another question there in the toolkit that, again, goes into more detail is, if I speak out, can my school or my employer investigate the harassment, even if I don't want them to? So for students, the answer is sometimes, right? So if a student goes to their school's Title IX office and reports that they've experienced harassment, they have the right to ask for help, meaning supportive measures. And that, we've already covered in the previous bullet. If they want an investigation, they actually have to take a further step and file a formal complaint. And so typically schools will not investigate a report of harassment. They will only investigate if they receive a formal complaint of harassment. But there are certain situations where a school will investigate even if they receive only a report and there has not been a formal complaint filed. So for example, if a school determines that there have been multiple victims alleging harassment by the same respondent, or if there is a serial abuser, a teacher or a professor who has been reported as an abuser, or if there was a weapon involved, there are a number of circumstances where schools have the discretion to decide that they do have to override the victim's consent and investigate even if the complainant has not asked for an investigation. But typically, again, the school generally will not investigate unless they are asked to. And that is under Title IX. A sort of a similar situation applies for workers. So again, the unsatisfactory answer is sometimes. Employers generally will not investigate unless the employee makes a complaint to their boss or to HR. But again, we highlight that if you report sex-based harassment that might violate federal or state law, then the employer must investigate or take some other type of action, even if the employee doesn't want them to. So we want students and workers to understand what their rights are and how a report of harassment can lead to investigation or not, so that they can have the right information to decide whether or not they want to report. The next question there, can speaking out publicly during my school's or employer's investigation affect the investigation? The answer is it depends. So Congress passed a law in December 2022 called the Speak Out Act. And specifically, it says that if you signed a non-disclosure agreement or a non-disparagement agreement before reporting sex-based harassment, then that NDA cannot be legally enforced against the person. So non-disclosure agreements are where someone might promise not to disclose certain types of information, and non-disparagement agreements are where they promise not to talk bad about someone. And so if a survivor has had previously signed either a non-disclosure or a non-disparagement agreement, and later they report sex-based harassment, then that previous NDA cannot be legally enforced against them, and they still have the right to speak out about sex-based harassment, even if it says in the NDA that they cannot. So that is great in terms of what are called pre-dispute NDAs, right? Things that you sign before the dispute of harassment occurs. What happens if you are asked to sign an NDA after reporting sex-based harassment? So oftentimes we see schools and employers will ask the survivor to keep quiet And in the toolkit, we highlight that Title IX and Title VII do not require survivors to keep quiet after they've reported. And so if their school or employer is asking them to keep quiet, it's a good idea to talk to a lawyer to find out what their options are. But again, the civil rights laws that are implicated do not require them to keep quiet. And then there at the bottom, can my school or employer punish me for bullying my abuser, bullying in quotes? So again, here we explain that retaliation is illegal, but unfortunately it does happen. So unfortunately, schools and employers could punish a survivor directly in terms of, suspension, expulsion, lowering their grades, firing, demotion, cutting pay, etc. Right? These are all common forms of retaliation that we have seen taken by schools and employers against survivors. Schools and employers can also punish survivors indirectly. So this can happen sometimes. We're seeing this pattern more and more where an abuser might try to get the victim in trouble by filing a retaliatory cross complaint and complain that the victim is in fact the bully or in fact defaming the abuser, or even saying that the victim was the real abuser in the situation. So this has sometimes happened, for example, in cases where the respondent or the abuser might say, well, I was drunk during the incident, so you raped me. You were the one who raped me. I was the rape victim. Or another common type of fact pattern that we've seen is if there is domestic violence and the victim in the domestic violence situation responds with self-defense, the abuser can cite the self-defense and say, well, you hit me and that was abuse, so I've been abused. And so we have seen these situations arise, and unfortunately they can take advantage of a complaint process, abusive process. And so victims can then be punished by their institutions through that process. So retaliation is illegal, and a lawyer can help survivors understand if they have a retaliation claim if these types of situations occur. So that is that question. We can move on to the next slide, please. So then there's a section in the toolkit about responding to a defamation lawsuit. So a common question that folks might ask is, what should I do if I receive a cease and desist letter? This is a letter that an abuser's attorney might send, intimidating sort of letter to a survivor saying, you better stop talking about this or I'm going to sue you. So in the toolkit, we highlight that a letter, a cease and desist letter from a private person is not a court order. So you can ignore it, but you should also keep in mind that if you continue to speak out, you should prepare for the possibility of being sued. So we tell survivors, if you want to respond, or if you're not sure whether you want to respond, or you think you don't want to respond, in any of these situations, it can be helpful to talk to a lawyer first. And it is especially important to talk to a lawyer if you do want to respond, because your response could be used against you later in a defamation lawsuit. Another common question is, what if my abuser is famous and what if they're not famous? So we go over two different types of plaintiffs in defamation cases. So a private figure is a person who is not widely known. And so if your abuser is a private person or private figure, then they have to prove that the survivor was negligent, meaning that when they spoke out about the harassment, they should have known that the statement was false. Should have known is the standard for negligence. But if the abuser is public, if they're a public figure and they're very widely known, then they have to meet a higher standard. And so then in that case, they have to prove that the person they're suing spoke with actual malice. And actual malice basically means either the survivor knew they were lying or that they were probably lying. So it's a higher standard than negligence. Then there are also what are called limited purpose public figures. So a limited purpose public figure is not widely known in the same way a regular public figure is, but they might be widely known in a specific situation. So, an example might be, and again, it differs per jurisdiction, but an example might be somebody says in a public space, in a town hall, or maybe in a public Facebook post, Me Too has gone too far and, there's cancel culture and blah, 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 and I oppose it. And then if a survivor responds either in that public forum in the town hall or maybe in the comments of this like public post that, hey, you're actually an abuser, then basically in that situation, the limited purpose public figure applies here because the person has basically created a public situation by going out and talking about Me Too, going too far, for example. And so in these types of situations, and again, it varies per jurisdiction how this applies, but that person might be elevated to a public figure status and then have to meet a higher standard if they were to sue for defamation. They might have to meet that actual malice standard instead, even if they're not typically a famous person in the rest of their life. What happens if I get sued? How do defamation lawsuits work? So I will not drag you through all of that, but the toolkit does explain that typically the defendant will have about 30 days to respond to a lawsuit. And then it also goes through and explains each stage of a lawsuit. Pretty high level, but just to give folks a sense of like each stage, what to expect, who's making the decision, what sort of the standard is, and what they should expect if they are to reach that stage of a lawsuit. What are common legal defenses against a defamation lawsuit in different states? So here, again, defamation law varies state by state. And so we can't say what are the defenses in a specific state, but we do give common defenses that are available in a lot of states. And so, for example, one defense is truth. If you said something that makes someone look bad, but it's true, then that is a perfectly good defense, and you are not liable for defamation. Unfortunately, truth can be very difficult to prove, and so there are other defenses that might be easier for a survivor to meet, even if they are in fact, telling the truth. They might choose to go another route instead. And so, opinion is another type of defense. So if you say something that cannot be proven as false, demonstrably false, if it is more of a subjective thing, or if it's hyperbolic, then it's an opinion. It's not really an asserted fact. And so, for example, if you say so-and-so is a monster, can you really prove that someone is or is not a monster, right? That's sort of an objective statement. So that could be an example of where you have an opinion defense. Consent is another defense, and this is very interesting. So, for example, if the abuser gives you permission to talk about what happened, then they have consented and they later cannot sue the survivor for it. And so, for example, in many situations, a victim and harasser might be exchanging communications after what occurred. And if the victim says, I'm going to tell people about this, and the harasser says, you can tell everyone, no one will believe you, right? That's no one will believe you is a common thing that harassers do say. And so if they say, you can tell everyone, no one will believe you, that is actually consent. And so that would be a defense you could deploy in that situation. Timing is another defense survivors can use. Each state has a time limit for when a person can bring a defamation lawsuit. And it goes from about 6 months in some states to 3 years. And so if a person sues a survivor for defamation and it's been more than that time limit, then timing can be a defense. And then we have some other defenses, absolute privilege and qualified privilege. So absolute privilege is a situation where some statements can never form the basis of a defamation lawsuit, even if they're totally false. So for example, statements that are made inside a court, a judicial proceeding, are protected by absolute privilege. Another are statements that are made to your spouse. So if you talk bad about someone, if you lie about someone to your spouse, you are allowed to do that. That person that you defamed cannot sue you because the law recognizes that spouses should have a level of communication that is protected. So those are 2 examples of common absolute privileges. Again, it varies in different states. And then there's what is called a qualified privilege. So qualified privilege is a statement that must be spoken with actual malice in order to be defamation. So again, actual malice means that you either knew you were lying or that you were probably lying. And it depends on the state, what type of situations can have qualified or privilege apply to them. But some common ones might be testifying before a state legislative hearing, or having a meeting with a state lawmaker, like a constituent meeting. In some states, it might be filing a Title IX complaint or an HR complaint. So it really depends. But qualified privilege basically means that you have to meet this higher, the person who is suing has to meet a higher standard because there is this privilege. And then finally at the bottom, does my state protect against retaliatory defamation lawsuits? Unfortunately, I cannot read the whole bottom of that. I apologize, I should have made the slides a little bit higher. Let's go find out what I said. If your state has an anti-SLAPP law, you may be able to use it to pause discovery. So discovery is the portion of a lawsuit, as I'm sure many of you know, where both sides ask each other questions and ask for different types of information to gather evidence. So if your state has an anti-SLAPP law, then the survivor might be able to use it to pause discovery, which can be very invasive and expensive. And ultimately, if they win the anti-SLAPP motion, they can dismiss the case and even make the abuser pay fees and costs. So the next slide actually will talk a little bit more about what anti-SLAPP is. That's just a very basic introduction. So
sorry to interrupt you. Before we move on to that next slide, may I interrupt you just to draw your attention to the chat, to the Q&A, because I think the question is really specific to what you were just talking about on this slide. So I'd love for you to speak to that before you move on to the next slide, if you don't mind. So they asked, what is the standard for suing a public or private person for defaming a victim?
So if the survivor wants to sue the abuser instead for defamation, is that the question?
That's my understanding. And Nicole, feel free to add clarification if we're not understanding you correctly.
Yeah, thank you for that question, Nicole. The standard is the same that I described before. You look at whether the person who is suing, whether the plaintiff is a public or a private figure. And so in the fact pattern I was describing earlier, it was the abuser suing the victim. And so the standard depended on whether the abuser was a private figure or a public figure. If the victim is the one suing the abuser, then the standard depends on whether the victim is a private figure or a public figure. It just depends on the status of the plaintiff. And then there is an anonymous question, are anti-SLAPP laws the only ones you were talking about today where there is a shifting fee structure for attorneys? That's a great question. Anti-SLAPP laws are not the only fee shifting structures that are available. But I will, if I can go back to this and explain the anti-SLAPP laws first. So if I forget, please remind me. So what is an anti-SLAPP law? A SLAPP is a strategic lawsuit against public participation. So a SLAPP is an abusive lawsuit that is filed to silence people who are speaking out about misconduct. And that can be many different types of misconduct. It can be environmental destruction. It can be political corruption. It can also be sex-based harassment. And so when people speak out about these types of misconduct, oftentimes they are sued, they're slapped. They're sued by someone who is trying to silence them. So in 35 of our states and US territories and DC, so there's 56 of those total, in 35 of the 56 states and territories, there is some form of an anti-SLAPP law. And so these anti-SLAPP laws cover different types of rights. So in some states, actually in most states with an anti-SLAPP law, you are protected when you engage in petition, your right to petition. So petition means asking the government to help you in some way. It could be, testifying in going before your state legislative proceeding, going before a local proceeding, filing some sort of complaint. Different states have different descriptions of what they consider to be a petition, but generally almost all anti-SLAPP laws protect your right to petition. There are some states of those 35 that I mentioned before that protect your right to speech. And specifically, it's about speaking in a public place about an issue of public interest. And I'll go back to what issue of public interest means in a second. Then you have some states that protect your right to press, which means, sharing information through the news, through media, and your right to assembly. Sometimes they use the word association as well, which basically means joining together with others in a group to promote a shared interest. So it really varies between states which of these rights are protected, but I'll give you an example to show you how that plays out. So let's say you're in a state and the anti-SLAPP law protects only your right to petition. That's the only thing they protect. So if you name your abuser in a legislative hearing, that's a form of a petition. So then it would be covered by your state's anti-SLAPP law. But if you said the exact same thing on social media as you did in the legislative hearing, that's not a petition anymore. You're exercising your right to speech. And so that same content would not be protected on social media. And so your abuser might be able to sue you then for what you said on social media, but not what you said in the hearing, even though you said the exact same words. That's one example. The issue of public interest, I don't want to get too into the weeds, but that's a really tricky place for survivors to navigate, because depending on the state that you're in and what the courts have decided or what the law says in that state, harassment may or may not be considered an issue of public interest, which is, pretty infuriating. But in many states, their anti-SLAPP law will cover political, social, or other concerns as issues of public interest, or they might say an issue of public interest covers XYZ things. And so then it is really, or they might not define it all. They might just say issue of public interest, and we're not telling you what that means. And so then the courts will go interpret that. And in some states, they have interpreted it narrowly to exclude harassment. In some states, they have interpreted it to include harassment in some cases, but not others. So, in our appendix, we sort of go over that and give you an idea of what courts have said in the past when it comes to, say, a Title IX complaint, a workplace sexual harassment complaint, talking about harassment in the media, what happens when people have reported child sexual abuse, et cetera, et cetera. Again, it's a developing area of the law. Anti-SLAPP protections have not been invoked as frequently with harassment as with other types of misconduct, like speaking about environmental destruction or political corruption, and so, or zoning issues. And so the law is still catching up to that. Discovery. So most state anti-SLAPP laws, like I said before, require the court to pause discovery during an anti-SLAPP motion. So once the defendant, in this case, the survivor, once the survivor files an anti-SLAPP motion asking for anti-SLAPP protections against their abuser, in most cases, the court is going to pause discovery. And that means that's a good thing, because discovery can be very invasive, very expensive, and quite frankly, traumatizing to have to look at all the information about the assault or the harassment, to be questioned under oath by the abuser's attorney about the incidents. And so being able to pause discovery during an anti-SLAPP motion is beneficial to the survivor. So fees and costs. If the survivor wins the anti-SLAPP motion, then ultimately, in most states, the abuser will have to pay the survivor's fees and costs. Fees meaning the money that is owed to the survivor's attorney, and costs meaning the other types of expenses that the survivor has accrued, such as postage, court filing costs, Xeroxing things, etc. Now, if the survivor loses the anti-SLAPP motion, typically they will not have to pay the abuser's fees and costs unless the court believes that the survivor filed their anti-SLAPP motion in bad faith. Typically, if they think that it was not a serious motion, or if it was filed only to delay the lawsuit from going further. Appeals. So if the survivor loses their anti-SLAPP motion, in most states, they're actually allowed to appeal right away. This is called an interlocutory appeal. And so they can appeal to a higher court and say, hey, I believe that I should have won my anti-SLAPP motion and had this case dismissed. I don't believe I should have to go further, to go through discovery, et cetera, et cetera. And so this is also very beneficial that most states will allow this immediate appeal, because otherwise the survivor would have to wait through the whole defamation lawsuit and then appeal at the end. So another benefit of anti-SLAPP laws. And I wanted to make a final note about timing. So if your state has passed or updated its anti-SLAPP law recently, then there is a chance that the plaintiff, the abuser, might say, well, it doesn't apply to this case. And so a lawyer can help a survivor argue that the law is retroactive, meaning that it applies to lawsuits that were started before the law was passed, but that are still ongoing today after the law was passed. So again, a lawyer can be really helpful in that situation. So then going back to the question from our anonymous attendee here, are anti-SLAPP laws the only ones you are talking about today where there is a shifting fee structure for attorneys? It's not the only one. California recently passed a bill that is, I believe it's called the Speak Out Act or Speak Your Truth Act. It's not an anti-SLAPP law because it doesn't use this structure of looking at what is an issue of public concern or an issue of public interest. It doesn't have all of the pieces of pausing discovery and the like, but what it does have is if a survivor is sued for speaking about sexual harassment or assault or other discrimination in specific cases, then they're able to be protected from it. It's actually, the law actually operates to create a new type of privilege. And so instead of using this anti-SLAPP law, which is a very specific type of process that protects people when they engage in basically First Amendment rights to petition, speech, press, assembly, etc., it actually just creates a new type of privilege. And so if you go back to the other slide about different types of defenses to defamation lawsuits, it essentially creates another privilege in that what are common legal defenses against a defamation lawsuit. It creates one other type of privilege. And it basically says, when you speak out about sexual assault and other harassment and discrimination, that communication is privileged and you can't be sued based on it. So it's an alternate route. It's a little wonky, sort of looking at the difference between a defense versus an anti-SLAPP motion. But it is another way of doing it. And I believe it offers treble damages, 3 times damages at the end if the survivor wins and is able to get the defamation lawsuit dismissed. And I think that takes us to the end of, right, so now we have resources to share with survivors. We have this defamation toolkit. Survivor Speaking Out, it goes through, it talks about defamation as well as other types of retaliation and anti-SLAPP laws, which we just went over. There's also an excellent defamation guide that was created by one of our coalition partners, Legal Momentum. Focuses specifically on defamation. It does not look at other types of retaliation, but it goes into a lot of depth about the defamation standards in every state. So to be clear, if you want to learn specifically about the defamation standard in your state, the defamation guide has a really good in-depth chart on that. If you want to learn about defamation as well as other types of retaliation that survivors can face and other types of considerations survivors should keep in mind when they want to speak out, as well as a chart about the anti-SLAPP laws in your state, then the Survivor Speaking Out Toolkit is where you want to go. But both are great resources we encourage you to look at. And then if you are an advocate working with a student, we encourage you to share the supportive measures FAQ. This is, again, like I said earlier, a resource that National Women's Law Center and Know Your 9 put together. It was co-written with students as well. As Emma described earlier, that process of going to student survivors, asking them what you would have wanted to know when you were harassed or assaulted, and that forming the basis of the FAQs then that we provided answers to. So that FAQ is, I've been told, has been very helpful. So we hope you will share that with any students you're working with. NWLC also put out a new resource called How Schools Can Support Survivors While Complying with the Trump Title IX Rule. So this is a fact sheet that basically explains how schools can, abide by the letter of the law when it comes to complying with the harmful anti-survivor Trump Title IX rule, but still do everything that they can to support survivors. And this is extremely important right now while we are waiting for the Biden administration to finalize a Title IX rule that will replace the Trump rule. And then again, for students, another really helpful resource is the Cost of Reporting report. The Cost of Reporting is a Know Your 9 report that was done interviewing more than 100 students about their experience of reporting harassment and being punished for it, experiencing institutional betrayal from their schools, And so this can be a very helpful resource for students to better understand, what they're facing as part of a larger problem, and maybe even sharing it with their schools so that their schools can understand how to not be a part of that problem. And then if you are working with a survivor who is a worker, we have a fact sheet here. It's a short fact sheet, Workplace Sexual Harassment, the Basics, which explains to workers what their rights are under Title VII. And then, of course, for legal assistance, I know many of you came to this webinar through the Legal Network for Gender Equity, so you know all about it and you might be an attorney on it. For those who are not, the Legal Network for Gender Equity is a network that connects people who've experienced sex discrimination in a school, workplace, or healthcare setting with attorneys that signed up to be a part of the network. And then those attorneys are required to give at least a first free legal consultation to folks who reach out to them. All right, it's 12:47.
Thanks so much, Elizabeth and Emma. That was a really helpful breakdown about all the incredible aspects of that toolkit, and how folks who are attending can use it to support survivors. So I apologize that folks are not able to see the Q&A function. So far, we have addressed all the questions that have been added there. So I did want to invite, we have about 10 minutes for questions. So I wanted to invite folks, if they have questions, to please share them in the chat if they are willing for the entire audience to see them. If you prefer your question to remain anonymous, feel free to use the Q&A function and we'll read that question out loud without attributing it to anyone specific. As we're waiting, though, for some of those questions to come in, I wanted to say, I wanted to start with one question, which is, so if people in this audience wanted to share this resource with other survivors, with other advocates, other attorneys, what do you think is sort of the best way to help get the word out about this amazing resource? And also some of those other ones that you mentioned too are really fabulous.
Start, excuse me, I can start, and then Elizabeth, would love to hear your thoughts. Yeah, I think for us, sharing this toolkit far and wide has been our strategy for getting it out there. Know Your Nine, primarily our audience is students, so we and we have a pretty large presence on social media, so have posted about it there to make sure that it gets in the hands of students. But we also encourage you all to share it with anybody in your network who you think may benefit from it. I think we've noticed that. And part of the impetus for creating this resource was that there was a gap in terms of having a comprehensive guide like this for folks who are supporting survivors and also survivors themselves who are experiencing retaliation and defamation. So would definitely appreciate that support in that way.
And I just want to flag that the link will be in the presentation that you can access via our website, but Emma also put the specific link to this toolkit in the chat. So wanted to make sure you all saw that. And sorry, Elizabeth, did you want to add anything to that question? Okay, great.
I was just going to answer Janica's question. Is it okay
fabulous.
to share widely with our plaintiff side employment law groups? Absolutely. Obviously, you all have a lot of experience with litigating probably some of these cases, and you can bring your own expertise when you're advising your clients, but we wanted to provide resources and information on other non-litigation aspects of the process too, so you can support your clients as much as possible.
Perfect. Thanks, Elizabeth. And that kind of, please continue to add questions to the chat, but I'll jump in with another as we're waiting because it sort of transitions perfectly with what you just said. So the toolkit, obviously, we have a lot of lawyers and advocates in the audience, and the toolkit talks about, when and how it can be helpful to speak with an attorney. So I'm wondering if you could maybe speak a little bit more about sort of your vision for how attorneys could use this toolkit when counseling clients, like what role you might see it playing either with non-attorney advocates and or attorneys when they're working with survivors.
Emma, do you want to go first?
You go for it, Elizabeth. Go for it.
Okay, so the question is how can attorneys use this toolkit, or how can advocates use this toolkit? Well, the toolkit is online. We've divided it into several sections to make it more manageable to a survivor who's reading it. We worked very closely with student survivors when developing the resource, and we heard very clearly from them that when students want to read this resource, they are in crisis And so we wanted to make it as accessible as possible to them. And, huge props to Emma and your team for helping us make sure that we made a resource that was student-centered and survivor-centered. And of course, it is geared toward workers as well. But we worked primarily with student survivors in creating it. But the resource, like I said, you can share the entire piece of it online. There's the FAQs itself, as well as a separate PDF for the appendix. And then there's also specific slices that are each about 4 or 5 pages long. So if you have a survivor who has specific questions about how to speak out, then you might just give them part A. If they have questions like, what should I know? What should I think about when I want to speak out? You might give them part B. If they're specifically coming to you with questions like, well, I'm a student, I want to know how this affects me at school, then you give them part C. If they say, I want to speak out in the workplace, I have some very, very workplace specific concerns, then you give them part D. And finally, if they are super worried about defamation, or they've already received a cease and desist letter, or they've been sued, then you give them part E. And of course, the appendix with the anti-SLAPP information is also super helpful at that point, or at any point really, if they want to learn more about that. So that's one way that we thought about parceling it out so that it would be digestible. And then of course, if you want to walk them through it, or if you want to let them digest it on their own and let them know they can also reach out to either of our organizations if they have more questions, that would be great too.
That was really great. Thanks, Elizabeth. I'm just giving you a moment to add anything if you had anything to add.
I think you covered it really well, Elizabeth. I think the only thing that I would add is, and I mentioned this earlier, but the way that we structured the toolkit was really meant to be rooted in questions that felt very accessible to students, even students of like a high school age or lower or younger. So, wanting to make sure that for you all as advocates, I know for those of us who may not have experienced retaliation or defamation personally, hopefully you can use this to get a better sense of like what questions students or workers may have who are going through it in the moment, like Elizabeth said, in crisis and really trying to figure out what to do. So hoping that it will be useful to you all in that way.
Yeah, I just want to name that. I appreciate how in-depth and comprehensive it is, while also having sort of these like small chunks or small bites that are also accessible and really responsive to the individual needs that survivors could have. So I think that's a real strength of the toolkit.
And I would just also add, I forgot to say this, but we also have the entire toolkit and the appendix, the anti-SLAPP appendix, translated in Spanish for monolingual or just folks who are more comfortable with Spanish than English. And we also have plain text versions of these resources so that folks who might be using a screen reader can use it accessibly as well.
And we can make sure that that's accessible when we post these materials on the website. So thanks for noting that. And we have one last question I see in the chat, and we probably have time for about one more if anyone else has a question. But this question is to you, Elizabeth. From Pilar, could you briefly repeat what you said about travel damages and how they arise?
Yeah, so thank you for that question, Pilar. I'm going to put the link to that law in the chat. So this is California Bill 933. And if you scroll to the very bottom, you can see that a prevailing defendant in a defamation lawsuit is entitled to not only fees and costs, but also treble damages for any harm that was caused to them. So not only do they get, not only can they get their harasser to pay their attorney's fees and their court costs, they can also get triple the amount of damages that for any harm that they suffered by being sued for defamation. And then there's also at the end of that provision, they're also entitled to additional punitive damages that are available under the California code. So, there's a lot of options available, and, hopefully it also operates as a deterrent to abusers who are thinking about bringing these types of retaliatory baseless defamation lawsuits.
I'll give folks about 30 more seconds to add any last questions, and I'll just note that Emma and Elizabeth have graciously shared their email addresses. They're on the screen here. So if you have any follow-up questions specifically about the content today, you are welcome to follow up with them. And if a question comes in the next minute or so, we'll be sure to address it. But in the meantime, Danny, can I ask you just to go to our last slide? So first, I just want to thank our fantastic presenters, Elizabeth and Emma. Thank you for all the time that you put into creating this toolkit, into preparing for this webinar. Thank you for all your insight today, and all the incredible work that you do to support survivors. Also, thank you to our audience. Thank you for your engagement. Thank you for your energy around this toolkit and your excitement about sharing it with other advocates and attorneys. Danny just added a link to our survey. We have 3 minutes before we hit 1 o'clock, at least on the East Coast where I am. So if you could take those 3 remaining minutes to click that link and to take our survey, your feedback is always really helpful for us. And you can also access the survey with the QR code that's on the screen. And if you are not already following the Law Center on social media, please do so on Twitter, Facebook, and or Instagram. That's how you can, I guess I should change that icon, huh? That little blue bird. Anyway, sorry. So feel free to follow us, and that's how you can get updates about resources like this one as they are developed and put out into the world. And while we know many of the folks in the audience are already members of our legal network, if you are not, please consider joining. Elizabeth told you a little bit more about the really valuable work that the legal network does. If you are interested in joining, the link to do so is here by this little computer screen icon at the bottom. And one last plug to please take the survey, which I will add once more to the chat. And thank you for those of you who have added kind words of appreciation, and we will see you all at the next one. Hope everyone has a good rest of their week.